Hi, good evening. Today is November 23rd, 2025, and it is 7:06 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home at the 2302 Britton Ridge Drive, Katy, Texas 77494. And this house is located in a subdivision. It's a gated community called Lake Point Estates. And my house is located 300 feet away from the home of a gentleman by the name of Robert Mueller, who is or was director of the FBI many years ago. And I'm also in front of another gentleman by the name of Joel Grade, who is the chief financial officer of Baxter International, who is a client of WebMD, a company controlled by a gentleman by the name of Bob Briscoe. And all this is relevant to this conversation. So today, to this evening, I'm going to offer demo D91-2, meaning the second part. So this is going to be really a three-part, I believe, demo. I delivered the first part, I think it was on Friday. This is the second part, and there's going to be a third part. It's going to be more technical. And I apologize in advance for it because I wanted to give the technical part today, but there's been a series of developments on the legal front that I think are important to record, right, for the record. And because I think, because of all the things that I discovered using software on this front, I think things are going to escalate to a point where they're going to implode soon. So it's important that these things are recorded before things implode, right? So I'm going to start with the legal front today, right, in part two, and then I'm going to do the third part, which is technical, in a separate session. Depending on how fast I can do this one, it might be later tonight or might be tomorrow. Tomorrow would be the 24th of November, because today again is Sunday, November 23rd. So, oh boy, where to start? So there's been a series of interesting legal developments. Well, I mean, they're not really developments; they're more like discoveries, right? I mean, these things already had happened, but I didn't know, right? But by using software and a little bit of help from the informant, I, was able to see a lot of things. And of course, I took action to not only disable them, but turn them into, how do I say this? It's like they did a series of things, design, and then you can see that you will see. I'll show you in a second, right? But you will see that there's design behind this, right? This series of things, it's multiple things, and all of those things were designed to torpedo the second writ of mandamus, so it would be dismissed procedurally again, right? But thinking of that analogy of a torpedo, what I did was that I didn't destroy the torpedo, I turned it around, right, and sent it again back to their way, but improved, right? Like I put some extra things on the torpedo before I sent it back. So that's why I say that things are going to implode, right? Because now they're all in the same documents, right? The family came together, right? So it's what I was saying on demo on demo 91-1, right? It's these high energy situations. If something, if there is if something happens by chance, right? If there is something that they cannot control, things can go terribly wrong. And I think this is going to be an example of that. Yet another example of that, right? I was trying to think of an analogy, right? On day-to-day life about to illustrate this high energy situation, right? And I think a good analogy, I was thinking about, what analogy could I give you? I think it's like when you go to the gas station to pump gas. I don't know if you've seen that when you go to the gas station, there's a lot of signs, right, everywhere next to the pump. that say, do not smoke, turn off your engine, don't use your cell phone, like all these prohibitions, right? That things that you cannot do. The reason behind that is because in gasoline there is high energy in that substance, right? And if there is a spark, it doesn't matter if it's electrical, if it's static, if it's actual combustion heat. But anything could spark that and turn everything into flames. And it's because gasoline is a high energy substance, right? There's a lot of energy concentrated in that substance. It's the same, right? It's the same thing here. These high power moves that they're making, right, and committing all these frauds and involving people that are family, if something is not controlled, and there could be something that could happen randomly that could turn everything into flames. And I think, right, the things that happened randomly here were the development of the legal pipeline. They could not foresee that somebody would create a piece of software that would see through this deception, right? And the second thing that they couldn't foresee was the informant, right, passing information to the target. So, it is what it is, right? So anyhow, I made a series of notes. So I have this calendar invite. I have this calendar, Google Calendar, right? And I put notes in it. I'm just mentioning this in case anybody is watching this, and right? And they investigate, or sorry, this timer again. You could see the calendar invites. You could see the talking points in there. So I'm going to start by sharing my screen with you. And I'm going to start going through the points, right? The talking points that I have. Now I have to say, I'm going to show you some things in some documents, right, that I already have put in the bucket. But the process of getting them from the bucket is going to take me a bit of time to find the things, right, that I'm trying to locate. So bear with me. I'm going to try to do it as quickly as I can. Okay, so the first talking point is the clerk, and not any clerk, right? So I'm talking specifically about the clerk of the First Appellate Court, which is a court that is directed by Chief Justice Adams. Right? He is a Chief Justice, and the reason why we have Chief Justices is because their job is to assure that the court runs smoothly, right? And there are no abuses, and they follow the rules and the procedures. So it is important to remember that the person responsible ultimately, right, for the functioning of the First Appellate Court would be Justice Adams. Now, the clerk as a weapon, right, and specifically the clerk of the First Appellate Court. This is a good example, right, of that thing that I've said multiple times, that when I see something that is unusual, I, by default, think the person may have made a mistake, right? I don't immediately think, oh, this person is trying to harm me. That's not the way I operate, right? And I explained the reasons before. Like, it's just not, it's unproductive to do that. It's counterproductive. So, with this clerk, how do I say this? There's been several occasions, several instances in the past in which, she's done things that are suspicious, but I haven't, I haven't drawn any conclusions from that, right? But with all the things that I found using the pipeline, at this point, it's undeniable, right? Like, this is not normal clerical procedures at all, right? So it's going to be a process, right, to go through all the procedural mistakes that were introduced into my filing after I filed. And all these procedural mistakes are attributable to the clerk, right? There's nobody else in the middle, right? Well, it could be Tyler Tech as well, the company that provides the e-filing system. But I would think that if it was Tyler Tech, they would have done this with the other courts, right? They would have introduced these mistakes with the 387, with the and that wasn't the case. It only happened in the two cases with the First Appellate Court. Not only in this new case, in the previous case, it also happened, right? But I don't want to get ahead of myself. I'm gonna start going through the observations, so you see, right? So what happened was the sequence. I'm gonna tell you the sequence, right? And this is important because it could be verified, right? All this is, and this is important, right? All this happened via electronic communications, right? So I'm mentioning this because that is the use of interstate wires. And if it was eventually, right, if authorities investigate these things and a link is demonstrated between Troy Pickett and the, and the clerk, right, then it would be immediately it would be, like a train, right? So right. So there is a folder in the Pickett. So I'm going to talk about something that is inside of the Pickett folder in the Google Cloud bucket. Okay. So there is a folder, a subfolder that is called. So it's within court evidence G Troy Pickett, and it's inside of a subfolder that is called actions taken to counteract. Let me see what it's called because I can't recall. Yeah, to counteract the weaponization of the clerk. That's the name of the folder. So you're going to see there's several filings there. I'm going to walk you through them sequentially in the orders because it's an iterative process, right, with the pipeline. So I run it, it finds some things. I rerun it with the things that it found, and I keep running iterations until it doesn't find anything else, right? So I'm gonna walk you through I think I run like 5 or 6 iterations, and it found same thing. I think 4 of them. So I'll walk you through the different iterations or the results of what I'm going to show you are the filings that I file in response to the findings of the pipeline, right? I'm not going to show you the pipeline, but I'm going to show you the document, like the finished document that I actually filed today, last night, yesterday and today with the court. And you will see how the documents, I'm going to walk you sequentially through the documents, okay? And you're going to see how the gravity escalates. Why? Well, because the pipeline, as it has more information, it finds more severe things, right? And I'm going to show you another example of this. And this is the normal pattern in software development. Like, the more data you have, the more precision you get, right? This is the reason why, as time passes, if you have a large scale system like Google or, I don't know, Bing or something like that, right? You have a lot of users. As time passes, your precision gets better, better, and better because you have more data, and the more data you have, you get better and better. The system gets better, right? So it's the same idea. So the first iteration, the result is this. So this is what I filed in response, right? So I'm going to walk you through the document because it says what happened, right? So what happened was when I filed the petition for writ of mandamus, the system, and I'm going to show you the screenshots that are attached to this document, and I filed this with the court. So now this is part of the record. So when you create a case, and in this filing system that the Texas courts use by default, which is called Tyler Tech, the first thing you have to do is to add the parties. You have to say who you are suing, right? Or the parties, like not necessarily, you don't necessarily have to sue everybody that is a party. You could also name like people like, I don't know, I think they call it amicus attorney, right? Or a mediator. Like there could be parties that are not necessarily opposing parties, right? But the parties. So you name the parties, and then you file the first document that you're going to file when you're going to create the case. And then there's a part where you have to specify the service, electronic service, meaning, who are the people that you're going to serve that document, right? The first document in the case. And when you do that, the first thing that you can do is add the parties that you declare in the first step to the service. And all this, may sound like mundane details, but this is very important. What I'm telling you is extremely important to show that there was fraud in the process, in what I'm going to show you. They manipulated my filing. So you add the parties, and then on the third step, you can add from the parties that you already added on the first step, you can add them as service contacts, meaning they would be served. Okay, so and what the system does is to copy the information from the party's information that you enter and creates service contacts with exactly the same information. Okay, and then you also have the option to add new service contacts. For example, if there's somebody that is not a party but you want to notify them that this is going on, you can add them as an additional service contact. Okay, and I added as a respondent Judge Brown, because she's the administrative judge of the 11th Administrative Judiciary Circuit of Texas that denied my second motion to recuse despite the evidence of fraud committed against 2 Texas courts. And it is her job to regulate those courts. So I added as well the trial judge that signed supposedly, right, the void order of October 15 that was signed after I filed the second motion to recuse that was denied by Judge Brown. And I also added my former partner as the real party in interest, meaning she is the person that benefited from that order, from that void order, right? And I added Troy Pickett because he is the attorney for my former partner, for the real party in interest in the 2 courts, right, upon which fraud was committed, the 387th and the First Appellate Court, where the Chief Justice is Justice Adams. And I also added Morgan Heibner from the Adams law firm, because she was the first attorney in the trial court that then attempted to leave the case when the fraud was uncovered. So I added all of them. And because I received, and this is mentioned, I think, in demo 89 or 88, I can't recall, there was an instance in which a person by the name Elizabeth Groth from the Adams law firm, and in her name in the electronic service, it said, in parentheses, Thomas Adams, which I believe is the father of William Kyle Adams. So I believe she might be married to Thomas Adams, but I'm not sure, right? That's what implied in the name that she has in her email address. But anyhow, I don't know, could be the secretary, I don't know. Right? But it's somebody that has a relation, at least a working relationship, or could be a filial relationship to Thomas Adams, who is the father of William Kyle Adams, who is the director of the Adams law firm. So there was an instance, and I described this before, in which Elizabeth Groth, parentheses, Thomas Adams, created a supposed agreement to withdraw Morgan Heibner, which I never signed because I would never agree to that. And then Troy Pickett, who supposedly is an attorney from a firm called OW Lawyers that has supposedly nothing to do with the Adams law firm, jumped in and canceled the agreement, the electronic agreement. And I got a notification from Adobe Sign saying that Troy Pickett was unilaterally canceling the agreement created by the Adams law firm. That fundamentally changes their attorney-client relationship with my former partner and even their finances, because then they have one less client, right? But Troy Pickett has the power to cancel those kind of agreements. So because this thing with Morgan Heibner, within the context of the Adams law firm, representing my former partner in the trial court, is in dispute, I felt obligated to add as a contact, as a service contact, Elizabeth Groth. Is the logical thing to do, because I don't know what's going to happen to Morgan Heibner, right? And I need to notify the Adams law firm that I'm filing this instrument, because ultimately they are the ones causing the harm. Regardless of Morgan Heibner, or if Morgan Heibner decides to move to a country with no extradition, that's her problem. But the entity that hired Morgan Heibner is the entity that is causing me harm, right? So I have to notify them that I'm doing this. So I added Elizabeth Groth as a service contact, okay? So far I had Elizabeth Groth, Judge Brown as respondent, Judge Telfair, the trial judge, as a other party, designated as another party, and my former partner as a real party of interest, and Troy Pickett as
as a service contact related to the real party of interest, right? Because he is the attorney that was before, that is in the two courts, really, and the one that committed the fraud, right? I mean, the ultimately made the monetary demands in writing, right, in a court filing. Now, it turns out that Morgan had already made monetary demands as well, based on the same fraudulent orders. But I had not catch this, but the pipeline caught it. I'll talk more about this later. But anyhow, so I filed this, right? So because I've been doing some tests, some experiments. It occurred to me to pull the data from Tyler Tech to ingest it in the pipeline, and I did that. When I did that, the first time, the pipeline flagged that the name of the judge, well, this didn't say the judge, it said the name of the other party, Oscar Telfair, who is the trial judge, I know that, was misspelled, right, in the Tyler Tech system. So when I look at that, I say, well, this is a serious problem, right? Because if you're getting a lawsuit and the name is misspelled, it could be dismissed, right? So I went and checked. And when I go and checked, what I find is that it was misspelled in the parties list, but it was not misspelled in the service contact list. And this is what I was telling you, all the story of how that service contact list got created. It got created by copying the contacts from the party list, which means that it wasn't originally misspelled. They misspelled it after I filed. So I created this filing, correcting the error, saying, hey, there is a misspelling, because I don't have the power to change it. Like, only the clerk can change those names. As a filer, as a litigant, I don't have the access in a Tyler system to change the name. So even if I wanted to create a misspelling, I can't. Right? So only the clerk has that power. So I created a document to memorialize what happened, right? And I'm describing the sequence. But there's also something very strange that happened, and it is that when I filed this thing, I filed the original petition for writ of mandamus on Friday, okay, in the morning, 9 a.m. In reality, I had filed it on Thursday, but I filed it on the 14th court, right? Hoping to get less, because I know that in the 14th court, there is less, and the number of justices that were appointed by Abbott are less, are only four. But on the first appellate court, 7 were appointed at some point by Abbott in some point of their careers to the bench. So of course, because of everything that I've discussed in demo 91, and I think the other one was in demo 2022, I think. Of course, my first reaction was to try to go to the 14th court, because both courts have the jurisdiction over the 387th. But of course, as I mentioned in the previous demo, D91-1, the TTP, all roads must be taken, redirected me to the first appellate court for a second time, right? Because this already happened on the first petition for writ of mandamus. But that's okay. I mean, they are within the right to do that, right? It's not a crime. So I go to the first and I file. So I filed on the 14th court on Thursday, but I got redirected again to the first, and I filed on that on Friday morning. When I filed on Friday, like at 11 a.m., I got an email from the e-Tyler system from the Tyler Tech system, saying your filing got accepted. When I see that, I'm at ease, because they're telling me that it's accepted, right? But when I ingest the emails in the evening in the pipeline, the email got flagged because it says accepted, but it also has a note that says the name of the children must be redacted. And that is contradictory, because if there is a problem in the filing, the normal procedure for the clerk is to reject the filing until you fix the problem, right? There is no, it doesn't make sense. And I'm telling you this, being a pro se litigant for 8 months, right, on this intense campaign of harassment of these people. The normal procedure is if there is a problem with your filing, the clerk should reject your filing, with telling you what's wrong, you fix it, and you resubmit it. And it's an iterative process until you get it right. And then it gets accepted. It makes no sense that she accepted it, but made this note, right? So this note is just setting a pretext for a dismissal. or for not completing the service, right? Which is what happened next. But anyhow, she sent me that email, I mean, through the Tyler text system, right? Saying that the filing was accepted, but it had this note implying that there was something wrong with it. But she didn't exactly tell me where was that the missing, the redaction, the name of the child that I should have redacted, and I didn't redact it. So this is what made me curious and think, well, is it accepted or not, right? I wasn't sure. So I ran the pipeline to see if I found anything, and I pulled the data from Tyler Tech and I put it in the pipeline. And this is where everything unraveled, right? And this is one example of them shooting themselves in the foot, right? If she had accepted the filing in reality, I wouldn't have noticed any of this, right? So anyhow, the other thing that got flagged is that that email saying that it was accepted, I received it on Friday morning, okay? And I didn't hear anything from this clerk anymore on all Friday. Now, and this is observational, but in the previous case, in the previous writ of mandamus that got dismissed procedurally because Troy Pickett and Morgan Heibner created this fraudulent document and deceived the two courts at the same time, the First Appellate Court, where the Chief Justice is Justice Adams, and the 387. So they create when I filed that petition for writ of mandamus, the procedure was that the filing got accepted, and the clerk sent the notice of service, of the notice of filing. She served the notice to supposedly the parties, right? I got an email saying, this is a notification of service that this person has filed this. But in this case, on Friday, that did not happen. I did not get that email. There was no service. So this was strange, right? So when I wake up on Saturday morning, something like at 6:50 a.m., and this is all detailed in here, right? In this document, I put the timeline. So here on point 2, I say on Saturday, November 22nd at 6:50 a.m. So at this point, the court is closed, right? Like the courts don't work on Saturdays. I sent her an email because I have her email address, because she sent me an email in the previous occasion, right? In the previous case. I sent her an email directly to noemi.hernandez@txcourts.gov at 6:50 a.m. on a Saturday, right? I wasn't expecting a response. I thought she would reply on Monday. Only 12 minutes later, I get the service email. She sent it 12 minutes after I emailed her. I mean, cause and reaction, right? Like, this is not random. My read of the situation is that they would have not served me with the document if I had not asked for it. But if I asked, they had to serve it, because otherwise they would be, there would be a proof that they are, obstructing justice, right? But this already is highly suspicious, because why is she serving me with that document on a Saturday, right? 12 minutes after I emailed. But okay, you could say, well, she's a diligent clerk, right? And she happened to be awake and in the computer at the time, and she saw the email and she served it. Okay, that's fine. But anyhow, so I take the data, I put it in the pipeline, and I see that the name is misspelled. So I create this document, memorialize the timeline, and saying that the name of the judge was misspelled, right? The judge Oscar Telfair, and he's an other party, right? And you can see here. So if you go to the exhibits on this document, you will see that she says the date says Friday 21st, right? So the document was going on Friday 21st, but she sent it really on Saturday at 7 a.m., 7:02 a.m., and only after I emailed her, and only 12 minutes after I emailed her, asking for this document. Now, the other thing that was strange is that when she sent me this email, she also attached a second notice that says that she was, well, that the office, right, the clerk office, modified the cover page of the previous case to correctly, and let me tell you what it reads exactly. It says, we substituted the front page of the opinion footnote to correctly reflect the trial cost number 25-DCV 328122. No substantive changes to the opinion have been made. But this is suspicious because, first of all, she's sending in this email a service notification about a different case, a new case, right? She has no business attaching. I mean, I think this is improper, right? Like, because the parties on this new case may not be the same parties of the previous case. So she may be disclosing information to people that shouldn't be seeing this. I mean, this notice, right? I mean, she has no guarantee that the attorneys are the same. Like, how does she know that how does she know that the people that are as service contacts in this new case are the same people of the previous case? It doesn't make sense to mix them in the same email. And this is a formal notification of service. So this is highly suspicious, right? Why is she fixing this error now on a Saturday and mixing that notice with this notice, right? It could be many things, right? It could be a way to justify that she didn't serve the other people, right? Because I'm going to tell you that later, but she didn't serve everybody, right? That's another problem. But we'll get to that later. But you can see here, right? My email from 6:50 a.m. and you can see her response, right? At 7:02 a.m. Right? And you can see that she attached two different things from two different cases. You can see the numbers here, right? So there's one notice from one case and another notice from a different case number. And remember, this is supposed to be the service for, you know, the original petition for writ of mandamus on this new case. It has nothing to do with the previous case. I mean, if you go by the procedure, right? But anyhow, it's another anomaly, right? So that was the first thing that got picked up by the pipeline. So I take all this, I put it back in the pipeline, and I run it again. And then it found this other thing that I'm going to show you. So then it escalated to this supplemental, right? In this supplemental motion, it finds that if you look at the service, if you look at the email that she sent me, right, it says that she's serving Morgan Heipner from the Adams law firm, right? And remember, this is coming from the first court of appeals, where the chief Adam is, the chief justice is Justice Adams, right? So she's serving Morgan Rivera Hartner from the Adams law firm, and she's serving G. Troy Pickett, right, from the OW lawyers, and she's serving me. So it appears as she's serving so the way it reads is that she's serving, supposedly, right, the attorneys, because I'm acting pro se. So in this context, I'm an attorney. I'm not, right? But in this context, I am treated as an attorney, right? Because I'm representing myself. So that's the way it reads, right? But this got flagged. Why? Well, I mean, this is something that I see. Well, you know, this is actually pretty good. It got flagged because Judge Telfair, in this case, is not designated as a judge, as a respondent. He's designated as an other party, and his name was misspelled by them, right? So if you look at the debug, the pipeline couldn't match his name because, you know, the name didn't match. Like, you know, the pipeline has a process of normalizing the names before matching them, right? So the lower cases them and all that. But the pipeline could not match with confidence the name of this party from the data that was being pulled from the Tyler Tech system with the name of the judge of the entity that represents the judge in the pipeline, right? So for the pipeline in that run, this person was a different person. That is not a judge, right? But is represented as other party. So the inference in the pipeline is, if this person is other party, why is that person not being served? And that got flagged, right? So this service is invalid because somebody who's a party to the suit, to the action, is not being served, right? you could make the argument, I mean, you could think, I mean, this is what they wanted me to think, right? That the judges don't get served here. Only the lawyers for the real party in interest and the petitioner, right? That's the realtor. That's what they want me to think. But if that was the case, Judge Telfair, with the misspelling, should have been served, because it's impossible that they could have think, if it's misspelled, how did they match it to be a judge, right? And the email address that is in the service in the parties list, and therefore in the service contact, is an address that it's a generic address, like it doesn't have the name spelled. So it's not like, oh, we found them because we saw the name in the email, right? So let me show you. But I think I should have showed you something before, and I did not. Let me go back to that. Let me do this first. Yeah, so what I wanted to show you is the screenshot of, so this is the party list, right, in Tyler Tech. And you can see, sorry, this is the list of service contacts. You can see that his name is correct, right? Oscar Telfair. But if you look at the party list, you see it says here party name, right? And let me see if I can increase this. Right. So you see it says party name, right? So what they did, they removed the last R of the last name. So it says Oscar Telfair, right? Without the R. So it's misspelled. But if you look at how it's spelled in the service contact, see it says service method is served, and it says Oscar Telfair with R. And remember, this contact got created from the party list when I filed, the moment before I filed. So if it got created correctly as a service contact, it means that it was spelled correctly as a party in the party list. But they changed it afterwards, right, to create this error in the docket, right, that could justify a procedural dismissal via the name being incorrect or via an undeliverable service, right, because the judge never got served. But the whole thing backfired, because if it's misspelled, then he cannot possibly be identified as a judge. And if he's not identified as a judge, then why he's not being served? If the argument is that, well, we only serve the non-judges, right? That could be the argument that they could make. But if that's the case, they should have served him because the name was misspelled, right? Then, therefore, he could not have been identified as a judge. So it's kind of a catch-22 situation that they have in their hands, right? How they're going to explain that, I don't know. But anyhow, going back to the second iteration, right? The pipeline found this, that in the service email, in the actual notice of service, the clerk sent, and this is the clerk of the First Appellate Court that is managed by Justice Adams. He's the Chief Justice. So if you look at the notifications, this one, right? She is serving the real parties in interest, 2 attorneys, right? The 2 that committed the fraud against the 2 courts, and me. But she is not serving Oscar Telfair, right? As they misspell it, who shouldn't be identified as a judge and therefore should be served. So when I see this, I see, well, obviously what they're doing is creating an invalid service to justify dismissing the action, right? Because the parties were not served. So I went back and looked at my records. And when I did this, if you see the second notice that she sent me, right, it has the same flaw. That when they served me for the other case, they didn't serve Oscar Telfair, who was a respondent in the action. They should have served him because he's a respondent. How can you process a lawsuit against a party and not notify them, right? And according to this process that I'm seeing, it seems like it's the job of the clerk to notify the parties, right? They don't let the pro se litigants notify them, right? Via the court system. This is a role that in this case, in this court, the clerk takes upon themselves to perform. Now, I don't know if this is the procedure in every case or if this is the procedure only in my case, right? Could be that they change the configuration somehow so I can serve people in Discord, right? I don't know. Yeah, I don't have any way to know because I don't know anybody who has litigated a case pro se in Discord. But it could be, right? It could be a way to do this. But anyhow, and then I remembered that when the first writ of mandamus happened, because I'm such a proactive person, right? I went and I served the judge in person, Judge Telfair. So that's why they couldn't dismiss it procedurally on that excuse, based on that premise, because I served him personally. But Judge Brown, I could not serve her personally because that court does not accept filings in person or electronically. The only way you can file a document in that court is if the document is forwarded by a lower court. So I cannot serve her, right? It's impossible. Right? So I understood why. I mean, they probably were trying to do the same thing in the previous writ of mandamus, is what I'm trying to say, because I see the same TTP. The judge, the respondent, the most important party in this lawsuit wasn't served in the previous writ of mandamus, but they couldn't trigger that trick because I went and served him in person, right? So they had to fall back to the deceptive title TTP, right? So that was really a fallback, and that's probably why it backfired. Now that I'm telling you this, let me tell you, when I went serve Judge Telfair, and I have this recorded somewhere, and this was outside of the, this was, I mean, I wasn't in the courtroom. It was outside in the hallway. So in the hallway, they have, it's like an intercom, right? And there is that you have to press a button to talk to the court coordinator of Judge Telfair. So I went there to serve him, and I, rang the buzzer, and she wouldn't let me in. So she called somebody to come from outside, talk to me, and get the document from me. Obviously, she didn't want me to see her face, right? Or to be able to recognize her, right? But she didn't let me come in to deliver the document, right? Which is unusual. Like if you're running a court, you have to receive service of documents. Like how can you operate a court and be enclosed in an area and not let anybody in, right? I think it's too obvious, right? That she was avoiding the personal service. I don't know, just an anecdotal observation. So this was on the 387th court, okay? But that's the reason why they couldn't pull that trick, because I served him personally, right? Of course, at this time, I couldn't do it. So they went ahead and tried to do this, right? So when she serves me, I'm talking about the clerk of the first appellate court. Sorry, when I went to serve Judge Telfair, it wasn't the coordinator, sorry, I misspoke. It was the clerk. I rang the buzzer of the clerk of the 387th, and she wouldn't let me in. She called somebody, and I had to wait there until this other person came, and that person did not come through the door. That person came from outside, and it was an external lawyer. It wasn't a personnel of the court. Like she called somebody to ask them the favor to come get the document from me, and then that person went in through the door and delivered the document, and that person wasn't an employee of the court. It was clearly a lawyer or a paralegal, because the person was with the client next to them, and both this legal professional and her client were able to come in, right? So it was mind-boggling to me why the different treatment between two citizens. I mean, I'm a citizen of this country as well, and if that citizen can come in, why I can't come in? I mean, it's just it's hard for me to understand how they make those decisions, right? Who can come in? I mean, is there a rule? Is this written anywhere? I don't know. So it seems like if you're not part of the club, you cannot come in and talk to the clerk of the 387th. That's what I got, right? I don't know. So anyhow, in the first appellate court, the clerk did the thing where she only notified selective people that she picked from the list. So, and when I see this, I started checking on the list who else she excluded, obviously, right? So you see, in this list, the key people missing are Judge Brown, the main respondent, the most important party in this service is missing. Judge Telfair is missing, the second most important party. Elizabeth Groth, parentheses, Thomas Adams is also missing. And she is important because the presence of Morgan Heibner, in this case, is contested because she wants to move to a country without um, extradition, right? So I have to notify the Adams law firm. But that person got removed. So it's obvious that the clerk, if you see this scenario, any logical person that sees this can see, I imagine, right? That I'm not the only person that can see this, that the clerk is selectively picking people from the list of service contacts and serving only the people that she picks, right? And leaving out the most important people in the service, right? So this is a recipe to get the writ of mandamus dismissed, right? So you see, so far, they've created three independent things to potentially get it dismissed. One, the missing service to the respondent, Judge Brown. She's not there. Second, the missing service to Oscar Telfair. He's not there. He's not in the service. Three, the misspelling of the name of Oscar Telfair. He's not there, right? And maybe even four, the missing contact in the Adams law firm, because they could claim, well, Morgan Heibner just moved, right, to, I don't know, Malta, right, and she's living in Malta now, and we can find her, and we never heard about this. So the whole thing is again mute, right, because it wasn't served properly. But okay, so what I did again, it was to correct the error, right, and put it on the record. So I attached all this, and this is what I said, that I returned the torpedo with extra ammunition, right? So I attached as an exhibit G that screenshot of the email from the Adams, from Adobe Sign, saying that the Adams law firm had created this supposed agreement to withdraw Morgan Heibner so she could move to Malta. Well, it doesn't say move to Malta, but that I imagine, right? But that they created this agreement to withdraw Morgan Heibner from the case, and Troy Pickett canceled the agreement, right? And this exhibit is relevant in this filing because it shows clearly that this is a contested issue, the presence or no presence of Morgan Heibner in that case in the trial court, right? So therefore, it justifies the notifications, the service, the need. It justifies the need for the service of a high-ranking officer at the Adams law firm, either Elizabeth Groth or William Kyle Adams, or Thomas Adams, or the three of them, right? So all the sequence makes this exhibit relevant, right, to this filing. So I filed it. And of course, I corrected the yes, I corrected the omission, right? Saying that the contact at the Adams law firm is missing. And I added my certificate of server, making it more specific, saying that I'm including all the parties, right, in this service request, including the Honorable Susan Brown, the Honorable Oscar Telfair, parentheses, with the correct spelling of his name, and Mrs. Elizabeth Groth as designated service contact for the Adams law firm via the court's electronic filing system, right? So it's clearly spelled out in the certificate of service that I'm correcting all the errors made by the clerk. And in the body of this filing, it's clearly explained why that exhibit F that shows Troy Pickett canceling the agreement, withdrawing Morgan Heibner, why that exhibit is relevant, right? It's spelled out here. So then what I did, right, I took all this and I ingested it again in the pipeline, and I think this was like the fifth of the sixth run. I can't remember. And then it found this, right? That the Honorable Judge Susan Brown was missing, right? This was the last finding, that she's also missing from the certificate of service, right? And that Oscar Telfair is also missing, right? And then I detailed, well, at this point, this is a pattern of omissions. I mean, there's so many. It's like, if you think about it, right, all the things that I'm telling you, all of these are reasons to get this thing dismissed procedurally. And it's obvious that this docket, being 1 day old, had been already plagued by the clerk with all these series of serious omissions. All of them, any of them, could be grounds for dismissal procedurally, right? So it's a miracle if this thing survives to be reviewed by a justice, right? Unless I use technology like the one I'm using to find these things, right? And to correct them proactively. But you see, if I was using a firm, like if I was using a real lawyer, right? Like if I wasn't using software to do this, if I hired a lawyer, even if the lawyer wasn't compromised, imagine that I can get to a lawyer in Katy that is not part of the network, right? Which it's not possible, and I explained in the previous demo why. But imagine for a second that was the case. Do you really think that a regular law firm, I don't know, I don't want to downplay the level of effort they put on their clients, right? But if you're a busy law firm, right, and I don't have I don't have millions of dollars to spend in lawsuits, right? So probably I won't be able to afford the most expensive, the top tier, right? So I'll probably have to go with a law firm that has a lot of clients. So if you're a law firm and you have a lot of clients, do you really think that a regular law firm would put this level of detail to catch this series of procedural mistakes, quote unquote, that they have put into this docket? It's impossible, right? At least one of these would get by, and the thing would get dismissed. So the only reason why I can fight this is because I'm doing it pro se, and because I have a skin in the game, right? I can devote hours of software engineering to solving this problem, because that's the only way for me to survive it, right? So it's a tricky one, right? And this ties back to what I was saying in one of the demos before, that this system, this professional circle, needs to be democratized. Like this situation, these people are going to control the world, like in this way, right? Because if you think about it, right, really, what is the most powerful profession in the world? It's probably this one, because they can interpret the law in any way, right? The law is ambiguous sometimes, and it can be interpreted, right? And if they control the entire circle in a specific area, they can do whatever they want. They can take your property. They can take your children. They can take anything. They can put you in a mental institution. They can medicate you. They can put you under a forced medical treatment, even if you don't want to, right? They can put you in prison. They can basically torture you with medicine, right? Like they can do anything they want. Like the law has provisions to do all those things. And if they control the law in this way, with these procedural tricks, they can do these things to anybody, right? So it's really something that somebody needs to do something, right? This is a very dangerous situation. Right. So I submitted this, and again, in my certificate of service, I made the point to say that I'm serving everybody, right? Right. And then I addressed the other point, the thing that she put in the when she accepted the filing, but put that note, right, that says that the names of the children need to be corrected. Which, if you think about it, right, the way it was written, it seemed like a generic note, because I only have in this suit one child, right? So she should have said the name of the child. But by saying children, I could be misled into thinking that this is a generic thing that they put into everything, right? Because if she read the filing, she should know that it's one child. Right? But anyhow, I did the process and I looked it up and I found the occurrences. There was only one that I missed. It was because I took a picture with a camera of the. There were two, actually. I took a picture with a camera of the fraudulent document when I got it from the clerk on the 387th, and that thing wasn't redacted, right? It had the name of the child. And there was another one in the fraudulent void order that Morgan Heidner submitted to the 387th, and the judge signed after the motion to recuse was filed. and that order was, besides the point that the order was contested and that he had promised to give me a hearing for the 16th, he signed it on the evening of the 15th, sorry, on the evening of the 15th, after the motion to recuse was filed. And I know that because the index numbers are consecutive, right? So his signature is after my motion to recuse in the document. So anyhow, in that order, there was another instance in which she put the name of the child in the middle of a paragraph in the page, I don't know, 33 or something like that, right? I don't know. Probably to make it more difficult to catch, I don't know. But anyhow, I redacted the things and I filed an amended, an amended, I think I can probably show it to you here. No, it's not gonna work. Let me see, 1 second. Let me download it real quick, because it's 200 megabytes or something like that. Yes, this one. Okay, I can say it. Yes, so a leave to amend the petition, right? To file a new petition with the redacted, with the name of the child redacted everywhere. Those two things that I missed. But importantly, in this one, I also put more in the torpedo, right? So here I'm saying that I'm serving everybody and also William Kyle Adams, who is the principal of the Adams law firm, who is the firm that employs Morgan Heibner, who committed this fraud. So because Morgan Heibner is in this limbo state in which nobody knows whether she's here or in Malta, like she could be anywhere. William Kyle Adams ultimately is the person responsible for what that firm does, right? So he needs to clarify what is his position. Well, imagine, right? After receiving this service, he needs to clarify what is his position regarding the fraudulent orders. Is he going to say that those orders are the orders that the judge rendered on September 11th, or is he going to turn on Morgan Heibner, right? But he has to take one position. I imagine, right? Because he's the director of the controlling partner of the Adams law firm. Like, he's not an employee, he's the owner, right? He's directly benefiting financially from the crime committed by Pickett and Morgan Heibner. So he has to take a position whether he backs them up or whether he turns on them, right? And I'm curious to see what it's going to be. And it is justifiable that I serve him because Morgan Heibner already filed a document with the court saying that she wanted to withdraw from the case, right? So somebody has to be responsible for what has happened, right? So that's that. And I, of course, attach a proposed order to a leave for the judge to grant this motion for leave to amend, and also attach the proposed amended petition of writ of mandamus, right? Which has all the legal requirements of this document met, right? According to the procedural rules of Texas, of civil procedure in Texas. And this document explains the fraud upon the two courts perpetrated by Pickett and Morgan Heibner from the Adams law firm against the First Appellate Court that is directed by Justice Adams. And it details all that, right? And it details how Pickett filed a document with the 387 court contradicting himself. So all this is detailed here, right? And it has all the attachments, including the TRO, the temporary restraining order, that was filed with the First Appellate Court, and that they didn't even look at it because the case was dismissed as mute as a consequence by the deceptive filing, the fraud that Morgan Heibner and Pickett perpetrated. And I think importantly, let me see if it's here. Yes. So this is a very important document, right? So this is in page 28 of this amended petition for writ of mandamus on this new case. This is the opinion emitted by this very same court, which is directed by Justice Adams, in which they are of the opinion that the case is dismissed as moot because the order supposedly had been signed by October 14th, which is what is the essence of the fraud of Pickett and Hyman. And you can see here that in the per curiam section, it says panel consists of Chief Justice Adams and Justices Morgan and Dokupil. Right? So Justice Adams personally signed that dismissal as mute, right? And that might be a relevant fact, right? So that document is included in here. And here's the deceptive document that Morgan Heimner filed in the 387, and that Troy Pickett is aware that it exists, right? That has the fraudulent title that does not correspond with what the document says, which was the basis for Justice Adams and the other two justices to dismiss the petition as mute, therefore denying me the right to be heard and to get appellate review of that violation of my civil rights. So anyhow, I filed that, and I've served everybody through the electronic system. But it doesn't stop there, because I learned, right, from what they do. I went one step further, and I did this little number that I'm going to show you. Yeah, this one. So I proactively created an electronic service myself and served them all, including the two judges with the correct spelling of their names. I also served, so Rebecca Bright is the clerk of Judge Brown, right? This 387th email is the service email of the 387th court. I served Troy Pickett, right, who is the architect of the legal strategy on the opposite side. I served William Kyle Adams, the other law firm, because he is the principal of that law firm. That attorney is in limbo. Like, nobody knows what's going to happen to that attorney, so he has to take responsibility, right? While the situation gets resolved in regard to whether the attorney will withdraw or not. Elizabeth Groth, because she is the person that attempted to withdraw the attorney, Morgan Heimner, by using a document saying that I had agreed to that. It was another fraudulent document. I did not agree to that ever, verbally or in any way, right? I also served Morgan Heimner, just to be safe, and the real party in interest, and I even served myself. I did this, right, because I cannot depend on the clerk picking, who she's going to pick for serving, right? Because then she can make a decision that could make the case be dismissed procedurally, right? Troy Pickett could come out of the woods saying, hey, this document is invalid because you didn't serve this judge. So I'm not going to allow that to happen, and I proactively serve them using, and this is important, a system called R-Mail. And this system is an electronic mail, so an email system that is compliant with all the US courts, meaning that it has a registered mail feature that is accepted by the US courts. So this is a legally valid document that proves that I served them electronically, okay? And it has a law, an auditable log that shows what happened to the delivery of those emails. So, this is equally valid in terms of, legal validity as the emails that come out of Tyler Tech, the eServe system. So, now I don't, and I worded this as a very professional service, saying, this is a supplemental service, and you can read what it says here. Oh, no, sorry. I'll show you what it says. This is just the proof, right? So this is just like the proof that I sent it. But there is another one document in that folder. That is this one. That starts with the word Gmail. Right? And it has all the files that I attach, right? I basically attach the amended, so the motion for leave to amend the petition, which includes the amended petition. And I also included the three different filings of two today and one yesterday, correcting all these clerical errors that were obviously implanted into the docket, right? And I wrote a very professional email, saying, this is just a service email. Here are the files, and listed the files, the cost numbers. Like, this email has all the requirements for a valid notice of service. And I checked this already against the pipeline. So there's no way that they can say that they were not served, right? So in short, I corrected the problems in the service, even if the clerk doesn't serve them tomorrow. These are already fixed, right? I can prove that I served them. Secondly, I served everybody. In third place, I corrected all the clerical errors. And in fourth place, I corrected the two missing redactions in the exhibits. The redactions needed were not in the document itself, in the petition. I mean, they could have rejected the exhibits, right? But of course, they're not going to do that. They're going to try to reject everything. But anyhow, I fixed those redactions as well. And after the fact, I communicated with the informant, and he confirmed that they saw that. He told me that this afternoon, a few minutes before I started this meeting. And he told me that they saw it, and the conclusion they got to is that they don't see any easy way to dismiss this procedurally, right? Which is what they want to do. They want to dismiss it procedurally because, again, if they get me in front of a microphone, I'm going to get into the records things not only about them, but also about the people that hired them, right? Control them. So that it seems like quite a situation that they have, right? The informant also told me about a family crisis, right, that is going on. But I'm not going to get into that subject yet. I'm going to wait until I see what they do with my parental rights. If they are still going to keep them, keep me hostage, and suppressing my parental rights, then I'm going to fire that. Right? But I have that information. I have proof of that as well. All right. So I think it's enough on that topic. Let's see. Yes. So this is important. So I'm going to move to the second item, right? So the pipeline flagged that Morgan Heimler had in fact made monetary demands. Sorry, the timer again. So annoying. Morgan Heimler made monetary demands indeed, which perfects the wire fraud crime. And that would be, so I think I put her on a separate bucket, I think. Let me see. No, so she's inside of the bucket of Troy Pickett, right? Because she's a lower level. Like Troy Pickett controls the Adams law firm, and the Adams law firm control Morgan Heimler. So in here, you can see this email in which she clearly says, please send to the petitioner the payments for the apartment that was due on 10/01, 2025, and please ensure that the child's daycare is paid. These are clear, explicit monetary demands, right? That were never rendered by the judge on September 11 on the rendition of the orders. And she's doing this, as you can see, by electronic means, right? And this was on October 3rd, 2025 at 2:17 p.m. After she had filed that fraudulent draft on October 2nd, that ultimately got signed, but after the court had lost jurisdiction, and without giving me the opportunity to be heard, as the judge had promised on the 16th. So she's making these demands based on that fraudulent document that she intentionally filed, right, on the day before. So this shows a lot of things: intent, premeditation, planning, right? Yes, this is an interesting one. So the pipeline flagged this, right? And this I'm not sure. I have to, and I take this opportunity to ask the Venezuelan informant, if you can check with your lawyer to see whether whether this could hold in court. But so there is so the pipeline thinks that this could be a series of different crimes, right? And I didn't take note of the debug output with the numbers of the the statutes, right, that this could violate. But it seems like a lot. Like it's a chain of things from tampering with a witness, because this is designed to silence me, right? It's a coercion tool, and you will see what I say this, right? It's a way, it's an intimidation tool. But it ranges from that to engaging the police on a fraudulent basis. Like it has a bunch of different things. So it could compound, right, to the severity, to the, I don't know, to the charges, right, to the eventual charges that she should, I guess, face, right. Of course, that's not for me to determine, but from what I'm seeing in the software, it seems like this could be a thing. But please, if you can check, let me know, because if it is, I'll send a report to the, I imagine, to the FBI. I don't know. But anyhow, and this is laughable. Like this is really laughable. Like let me tell you what the order says. I don't know if I should show you. I should probably show you the actual order, right? Let me see if I can find it. Yes. So this is supposedly around page, according to the pipeline, page 174. Yes. So, I mean, listen to this, right? Like, really pay attention to what she's saying. I mean, she put this in an order, and then she got a judge to sign this. And this was contested. I mean, I contested this order, and the judge. So, I mean, I don't know. It's laughable in a way, right? When you read this, but at the same time, it's alarming. I mean, that a judge has the power to fabricate this thing based on something that a lawyer with only 10 years of experience wrote. I mean, it's an abomination, really. But listen to this. It says, notice to any peace officer of the state of Texas. You may use, so she's instructing the police. Do you think really that the police needs Morgan Heibner or even Judge Telfair to tell them what to do? The police is an institution that monopolizes the use of force in society. They don't need the permission of either of these people to do anything, right? But anyhow, she goes and says this. Notice to any peace officers of the state of Texas, and this is Morgan Heibner talking, this is not the judge. The judge never said this, and she put this unilaterally in the order, right? You may use reasonable efforts to enforce the terms of child custody specified in this order. And then she goes on and says, a peace officer who relies on the terms of a court order and the officer's agency are entitled to the applicable immunity against any claim, civil or otherwise. Like, I don't know, I lose the speech, the ability to talk when I read this. So she's saying that the police officer, as long as while they're engaged, not even what they do to me, but just while they're engaging with me, if that action is reasonable, they can do anything and they have complete immunity. They could shoot me. If I resist what they're doing, they can shoot me. And they have guaranteed immunity according to this document signed by a judge, right? They will have complete immunity, civil or otherwise, like even criminal. Like they cannot be criminally prosecuted for anything because Morgan Heibner said so. Regarding the officer's good faith acts performed in the scope of the officer's duties. The scope of the officer's duties could range from putting me in prison to shooting me, right? I mean, that's what the police do. I mean, they have those powers. That's why they carry guns, right? I mean, I'm sorry for laughing, but it's just I read this, and this sounds like an order designed in Venezuela. This is the kind of thing that, and sorry, I don't mean to. It's not a racist comment. I was born there. That's why I'm telling you that. I'm used to see these kind of atrocities there. Like you see these things there, right? Where you see orders written by judges that you read them, and the thing is, it's unfathomable, right? But, the officer will have immunity against any claim, civil or otherwise, regarding the officer's good faith acts performed in the scope of the officer's duties in enforcing the terms of the order that relate to the child custody. Any person who knowingly, and this is the most interesting part, because she's saying here something that could put her in prison. Look at what she wrote. Any person who knowingly presents for enforcement an order. This is exactly what Troy Pickett did on November 7th, right? When he filed that in court. Any person who knowingly presents for enforcement an order that is invalid or no longer in effect commits an offense that may be punishable. But so I'm sorry for laughing, but it's just laughable. It's laughable that they wrote something in the order that could put them in prison in the same order, signed by their own judge. I mean, I mean, I don't know. I lose the speech when I think of this. Right? It's you know, it's the apex of incompetency. Like you know, I just know how to say it. Any person who knowingly represents for enforcement, no, who knowingly presents for enforcement an order that is invalid or no longer in effect, which is what Troy Pickett did, commits an offense that may be punishable by confinement in jail for as long as 2 years and a fine of as much as $10,000. So I don't know. There's so much here, right, in this short paragraph that I don't know. Like I don't know. I don't know really what to make of this. But remember, right? I have a federal lawsuit for violating my civil rights, and I started this lawsuit months ago for violating my civil rights under the color of a state of law. And this is not the first time that Morgan Heibner, on the record, on the trial court, has brought up the topic of engaging the police. Like she has done this multiple times. So it's obvious, right, that she's engaging the police as a method of coercion, right, as a tool of coercion. And now she created this clause that basically gives immunity to any police officer to do anything they want with me, as long as the approach is reasonable. I mean, as they have a reasonable reason to approach me. It doesn't say that the outcome of the situation has to be reasonable. What it's saying that the reason for them to engage with me is reasonable. As long as that condition is met, they can do anything with me and they will have complete immunity. Imagine that this is a barbarity. I mean, if this holds in society, this would take us 200 years back in terms of advancement of the legal systems. This is a medieval order. Like she is giving a blank check to a police department that not only has the monopoly of the use of force among civilians in Katy, but that is also actively harassing me, right? And there's a lawsuit in federal court about this, right? I'm not making this up, right? So I don't know. So when the pipeline put these together with all the data that I have in the pipeline, including the federal cases, the list of potential violations is I don't know, it's like 10 different things, right? And if you add them up, it's a lot of years. So yeah, I don't know. It could be a lot of leverage to make her talk, right? If she's interviewed at some point, which I imagine she should be, right? She would be. I don't know. Right? I'm nobody to. I don't mean to overstep, but if she, if authorities investigate this and decide to interview her, there's a lot of ammunition in that short paragraph. And interestingly, right, because you cannot use it as sword as a shield at the same time, right? So if you're going to use it as a sword, you have to also be able to take it, right? So so Troy Pickett presenting that order fraudulent, knowing that it's fraudulent, and he knows that it's fraudulent because he represented 2 different days to 2 different courts in the same state of Texas, right? Using electronic means. So and he knows, the order is invalid, right? And he is presenting it for enforcement, right? He's saying this is the order, and you have no rights over your child, right? That's the definition of enforcement. Like he is precluding me from picking up my child from daycare, right? So I don't know if he cannot use it as a shield, right, and as a sword at the same time. So because he already used it as a sword, I think he should not be able to use it as a shield, right? And I think it should probably be used as a sword against him, right? Because what's fair is fair, right? So I don't know. I'll run the pipeline to see how I can put that into the federal court. So with that, I'm going to move on from that topic, right? So we talk about the multiple clerk errors. Okay, so now let's talk about the deceptive caption on, and this is a good point to show you this. Look, if you look at this order, right? Let me advance this quickly here. Right. So if you look at this, right, she created that document on October 2nd, and she put my name as Rinaldo J. Aguiar. And I'm mentioning this to show the TTP, but also to ask the Venezuelan informant if you could ask an actual lawyer if I can file for a motion to strike this document based on this wrong caption, because the caption is wrong. So she filed it with that name, right? My only Aguiar, right? Reynaldo J. Aguiar. But when she filed the original petition for divorce, and in many other filings, almost all the filings, she used my two last names. But here she used only my first name. So this makes the caption of this document invalid in regards to the document, to the docket. So if you look for the court, right? If you go for the Fort Bend Civil Court records, let's find the docket to show you what I mean. Right, so you see the defendant or respondent, it says Aguiar Marcano, Reynaldo J. So that order that they submitted, that they've been defending, with teeth, it has the wrong name. That's not the name of the case, right? So I could procedurally ask to be this stroke from the record, because this caption doesn't match and this is what they've been, this is a TTP on itself, right? So besides, so this was just to ask the Venezuelan informant if that would be a valid argument based on a procedural rule that cannot be ignored, right? Like the judge cannot ignore that because it's not an argument, it's a rule, it's a procedural rule. If it doesn't match the case, it's not valid, right? So that's the question for the lawyer. But besides that, the technique is that they intentionally change this so it doesn't match the appellate case, right? So in the appellate court, the clerk titled the case, styled it, they call it, as Reynaldo J. Aguiar Marcano, right? So, but this order that I'm challenging and all these things, right, saying that it's void and this proof of fraud, it doesn't match the name of the appellate court, right? And this is by design. So if I refer to the order, then I have an error in the document automatically, right? Because the style of the case doesn't say Rinaldo Aguiar, it says Rinaldo Aguiar Marcano. So I basically cannot refer to the order without violating the style of the case, right? So that's the TTP. But anyhow, it's just a procedural trick, right? And this is what you see in all the things that I described are these little tricks that they do. They're ruses, really, like they're deceptions to trigger tricks that could get the case dismissed, right, by procedural rules. So they don't have to get into the substance of the argument. Why? Because they can get into the substance because they're committing serious crimes and they could incriminate themselves, like as Morgan Heibner have done multiple times on the record on the 387th. Right? She has said multiple times things that contradict things that she's done or that prove that she's committing serious offenses. Right? And I have them all documented, and I've talked about them before, and they are filed in the 5 different motions for sanctions that I filed against her in the 387th court, that none of them have been addressed by the judge, by the court. But that's the deceptive caption TTP, and of course, so but I'm very aware of this, and I'm very cautious of always using the right caption, right? They're not gonna get me with that. Let's see. Okay. Yeah, so this is more on This is more on a philosophical note, okay? So in the previous session, in the demo D91-1, the first part, I mentioned this, let's call it internal conflict, right? That I had when I mentioned that I was thinking of increasing the reward that I offered to the Venezuelan informant. By the way, I have to tell you, right? I realized by the interactions that I have that, he's not after money, like, which is a concern to me, right, in reality, right? Because, he knowing how much energy is in this and how much money he could get, and he's not interested in that. Like, he has never asked me, like, send me a message confirming that you're going to give me, like, and of course, I understand, right? Because he's a state actor, a state level actor, the amounts of money that he handles, I mean, for him, I don't know, right? What I could give him would be peanuts, right? Compared to what he has access to being a state actor in an oil producing country, right? And working with or close to Diosdado Cabello, right? So, it's, I'm saying this because when I said, when I challenged his question the other day, and I said, well, but whatever I managed to get seized from them via whatever, right, the IRS, the DA, whatever, is something that you're not going to get. And he laughed and he didn't say anything. But the reason is because he's not concerned about that, because he's not after money. He probably has a lot of money, right? He's probably after something else, right? And I don't want to speculate, but it's obviously not money. Anyhow, but in the previous session, I asked myself the question, well, if I reward him, right, like if I increase the reward that I non-contractually offer to him, wouldn't I be falling into the same thing that I'm criticizing the Bizarro state from doing, which is rewarding people on alignment rather than merit? And then I go to the conclusion that, that he has merit because he's good at what he does. And the proof of that is that I'm advancing in this campaign at this exorbitant rate. But and then I realized that the factor is not really, it's not a question about merit or no merit. The question is really about who the actions of that person are benefiting, right? Who is benefiting from that merit? Is it him benefiting from it? Is it Diosdado Cabello benefiting from it? Is it the Bizarro state, that Bizarro society that they have benefiting from it? Or is it the real society, right? So the question is really where the benefit flows from his actions, and whether there's correlation between that flow and what he gets back in return. If that relationship is broken, then it leads to the communist paradox, right? Because people are getting rich and richer, but the society is not improving, right? And then, therefore, there is no alignment between the society's goals and the individual's goals, right? So they don't care what happens to society, right? They only care about getting richer, right? And in this process, people, if you generalize this and apply this same principle of reward to the entire population, everybody will be motivated on committing crimes, right? Nobody will be motivated in advancing society. And the society will decay, right, over time. And this will lead to a collapse, right? Like we won't be able to produce enough food to survive, all of us. So I had that thing in my mind, right? But so I ran this thing through the legal pipeline. What I did was to encode this in a way to ask if it would. I encoded it in a way, right? I encoded it as asking, would it be an offense? Would it be a punishable offense to reward the informant, right? And so the results are, are the conclusion is that no, it wouldn't, because in that context, it wouldn't as long as I'm not supporting him in committing any crimes. Right? If I know that he's committing a crime, I cannot participate in that. I cannot engage with him on anything. Right? And I'm not aware of him committing any crimes. But in this scenario that I'm describing, that he gives me information that helps me win the conflict, and I reward him for the information, it is not punishable because the information he's giving me is actually helping society, right? And So the analogy is, right, if one law enforcement agency rewards an informant with money, right? I mean, like I don't know. I've never, what I know is what I've read on the papers, right? But I imagine they give rules to the informants, right? If you're going to work as an informant, you can't be committing crimes. I imagine, right? They cannot give them a blank check to keep committing crimes. But even if the informant had committed crimes before, if they give information and they get a financial reward, is because the information they're giving is helping authorities, fight crime, right? So in that context, it's the same situation, right? It's an analogy, right? What I'm trying to say is that even though he isn't close to Diosdado Cabello in some way, right? Because he's getting this information, the fact that he is helping me in reality, say that I succeed, right? So imagine for a second, assume for a second that I succeed, right? And I managed to contact authorities and I managed to give all this information to authorities and it results on, people that are committing crimes being stopped and being prevented from committing more crimes. That will add value to society. Therefore, what he's doing is adding value to society. And therefore, that reward doesn't break the communist paradigm, doesn't contribute to the communist paradox, right? Because there is in fact a positive flow of value from him to the real society, right? So in a way, it would be reversing the dynamic. So I don't know, it's an interesting application of the technology, right? But it helped me solve that conflict that I had in my mind, of accepting, his help, because I have that in my mind, right? Like, what are his real motivations? But I think the way I have to say it is, as long as the information that he's giving me leads to advancing, not my personal goals, but my goals of deterring the network and maybe even helping dismantle it in whatever capacity I can help. That effort, that information flow is actually helping society, right? To give you an example, right? If that information about the hubs that this network have put surrounding Ukraine and all the roads leading and exiting from Ukraine, if that information reaches the Ukrainian government, that might save thousands of lives. So if he helps me get that information there, he's saving thousands of lives, right? So he's adding value to the real society, not to the bizarro state and not to the Diosdado Cabello. And in fact, he is taking value away from the Diosdado Cabello, right? So he's helping twice. So I don't know, that's an interesting observation. The other thing that I saw, right, the pipeline found a series of instances in previous, this came from the news pipelines. There's been cases, right, in which there's been cases of systemic corruption, right? More or less of what I'm seeing in this thing, right? In which the result after the thing gets uncovered and dismantled is that everybody that got negative decisions from those judges or officials immediately go and ask for a reversal, right? And this got more flagged as a what, right? And this is something that is hard for me to. I mean, I have numbers, I have the case numbers, I have names, right? I know people that could have been targeted with this. But so therefore, I have an idea, right, of the potential consequences for the local judiciary system, because it will get flooded with cases that will be reversed, right, or could be reversed, right? And it's alarming, right? What I'm seeing about the potential concept, but I don't know. I imagine authorities would have a way to solve this, right? I imagine, right? I don't know. I have no visibility into how this thing gets managed, right? But if that's the case, and all those cases get reversed, right? I'm talking about the cases that had been presided over by judges that are marked in the index. Right? it's alarming, right? To see that data, it's something that it's alarming. That I don't see. Again, I don't know, right? I don't have visibility on how that could be managed, but from what I'm seeing, it seems like it could be an almost unmanageable situation, right? It is a situation that is not going to be easy to manage. Is what I can tell you now. Okay. Well, the rest are a series of challenges that I see that Mr. Pickett will face. But I don't know if it's a good idea to. I mean, it's like it feels like beating a dead horse at this point. Right? Like he already confessed in writing, and so I don't know. I feel like it's not necessary really. But there's a yes. I posted here that this is like beating a dead horse. So I'm not gonna get into that. So I'm gonna close this session for now on the legal topics, and I'll do the technical session. Let me see if I can do it tonight. If not, I'll do it tomorrow. But I'll try to do it tonight. Well, thank you so much for your time, and I see you on the next one.